going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday? Happy Wednesday. I had to think about what day of the week it was. Happy Wednesday. Yeah, I don't really have much to say right now. We're just going to watch some court. You want to watch some court? I'm going to watch some court. Let's watch some court. I've got a bunch of clips for tonight. That's really all I have to say. We got a Tope update. We got a soft sit update. We got some attitude. We've got a pro se. We got, I mean, just about everything you want to see in court. We got tonight. So hopefully you enjoy it. I don't really have to say anything else. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go. Jesus said that, by the way.
State your name and date of birth for the record.
Amanda Guy, 04/17/1989.
Okay, what would you like to request today?
I forgot what it was called, but the first one you said that I...
Well, there's the contested hearing, that's the full trial. And I also talked about a deferred finding where you can keep the ticket off your record.
The
Contested?
Yes.
Okay, so once we do the contested hearing, you won't be able to ask for a deferred finding. Once we begin the hearing, then we complete the hearing and it's just like a trial and it's either basically committed or not committed, okay?
Okay.
All right, so the first thing I'll do is I'll read the officer's sworn statement into the record. This is a sworn statement by Officer Chris Patterson, done January 15th, 2026. It indicates infraction number 6A0093228. On the date and time listed on the notice of infraction, I was parked on the side of the roadway in the city of Black Diamond in my unmarked patrol vehicle. I witnessed the defendant's vehicle pass my location, and I could clearly see the driver holding a cellular telephone in their hand. I was approximately 10 to 15 feet away from the defendant's vehicle, which allowed me a clear and unobstructed view of the driver holding the cell phone in her hand. And then it indicates per RCW 4661-672, a person who uses a personal electronic device while driving a motor vehicle on a public highway is guilty of a traffic infraction and must pay a fine as provided in 4663-110-3. And then the uses are defined as either holding an electronic device, using a hand or a finger to compose, send, read, view, access, browser, transmit, or watching a video. I stopped the vehicle and contacted the driver. The driver told me she was holding her cup of coffee and not a cell phone. I informed the driver she was not holding a cup of coffee when she passed my location, and I know the difference between someone holding a cup of coffee and a cell phone. The driver insisted that I was incorrect, and I informed her that she was lying to me because I could clearly see that she had her cell phone in her hand when she passed my location. The driver told me she was going to fight the ticket in court. When I recontacted the driver with her infraction, the driver was on her cell phone and speaking with a male subject. The driver told me that she wanted to speak to my supervisor. I informed my driver my supervisor began his work shift at 4 p.m. She asked for my supervisor's name, and I informed her that his name was Sergeant Goddard and that he began his work shift at 4 p.m. She asked for my badge number, and I informed her that it was printed at the bottom of the infraction. Then it says, I certify or declare under penalty of perjury under the laws of the state of Washington, the above is true and correct, and I am entering my authorized user ID and password to authenticate it. Okay, so now I'm going to place you.
All right. Right off the bat. We have badge number, supervisor, you're lying. All right. Let's go.
You under oath, please raise your right hand. Do you swear or affirm that the testimony that you give today will be the truth?
Yes.
Okay, go ahead and tell me what you would like the court to consider.
I just pulled out of the coffee shop. I know where he sits. He sits in the same spot. I drive by probably 3 to 6 times a day. And um,
Um, I want to say this is Washington. I think this is Washington. This is Black Diamond. I don't know, Black Diamond Court. I think that's Washington. I don't know. But the only way to get the officer to appear in court is to actually subpoena the officer. Otherwise, their sworn testimony is enough. They don't have to appear in court. I think from what I've seen on traffic cases in Washington, I think that's right. Anyways, um, yeah.
I had a cup of coffee in my hand. When he went to pull me over, he pulled up behind me. When he went to pull me over, I simply just thought he was trying to get around me to go somewhere else. I pulled slightly off to the side, and that's when he came up to me. He was very arrogant, calling me a liar. I said I had a cup of coffee in my hand, and he pointed to a cell phone that he said that he saw that I was holding a pink cell phone in my hand, and that cell phone was my work phone that was turned off. And I even showed him that it was off. He just ignored it and continued to ask for my license and registration, in which I did, but he continued to kind of puff up his chest into my window and said that he had me on recording lying to a police officer, and I didn't. I just had the cup of coffee in my hand.
Okay. All right. So based on anything further that you want to share with the court?
I don't know if this applies to this, but I did file a complaint afterwards because he did uh, do an illegal turn right afterwards, and they investigated and came back that it was nothing. But
Okay. All right. Well, as I indicated, the burden of proof is just a 51% burden. In this particular case, the officer was very clear in his statement. And then in your statement, you indicated that it was a pink cell phone that was the discussion, and that he had said that he saw you on that. And so when I make my decision, I have to weigh the evidence one way or the other. And it is a very just slight burden of 51%, little more likely than not that the infraction occurred. So I do find that the infraction occurred. I understand that you disagree, and you are certainly welcome to appeal this court's decision. The penalty for the infraction is $150. Would you like time to pay that?
so this is all, you don't get to watch the video or anything to show that I showed him the phone that was turned off as
You can
evidence?
request that video if you like. It's not
No,
something that comes into
I
evidence.
did get the video.
Mhm,
But I'm based on the decision that you're making.
mhm.
It's just based on two people's
Yes.
saying and not the actual evidence of what actually happened.
So I don't think he had a video of you when he saw you driving by with the cell phone,
No,
right?
but I did show the video. No, he had the video that I did show that the phone that he was questioning
Mhm,
was turned off
mhm.
because they don't turn it on until I get to work at 10 in the morning. And so would that not be evidence to show that I was not on that phone? It would be silly for me to hold a turned off phone.
Ms. Guy, I understand you're frustrated with the court's decision. And again, as I indicated, you are welcome to appeal. If you do want to appeal, perhaps that's evidence that you can make sure the court reviews. However, I believe you that you showed him the phone and that the phone was off. You testified that. But I have to also take into consideration the officer's sworn testimony. So, that concludes your hearing. Do you want to have additional time to pay other than 30 days that I normally give?
No,
Okay.
I'd like to contest, though.
You can appeal it. You can appeal it to the
sorry.
Superior Court. Yes. You're welcome to do that. All right. And I'll just check your address here on 287. Okay. You'll get your paperwork from the court shortly, and you are free to leave the hearing. Thank you.
Okay.
All right. The next matter.
All right, so that's how we're starting it off. And yeah, no, I see a couple of you. I know Vic, someone else said it too, that the officer's not there. Yeah, I don't know. I don't know how it works. I really don't. I'm not a lawyer. But I will tell you, I don't know, 90% of traffic cases, the officer's not there. I don't know. But Washington has a lot of loopholes in their traffic laws where they have actually entire dockets to dismiss traffic cases. And it's amazing. So there's one. It was at Cowlitz County that they dedicate an hour, what, twice a week, just to dismiss traffic cases for officers who, didn't sign the ticket or didn't put down their jurisdiction, like just weird things. So I don't know. Washington's weird, so I'm not going to argue. Not going to, but yeah, for as much court as I've seen across different states, the officer's not usually there for traffic tickets. Yeah, not saying it's right or wrong, just saying that that's what I've seen. Anyways, we're moving on. I don't know what's next. I have no idea.
In the orange?
Oh, this one's
Robert
good.
Trobashevsky.
I think Twitchy sent me this. I think it was Twitchy. Pretty sure. Was it Twitchy or Lucy? I think it was Twitchy.
One. So Dobashevsky, you're before the court on a felony complaint. That felony complaint alleges that on or about March 9th of 2026, at the location of 2717 Brooklyn Drive in Ypsilanti Township, Washtenaw County, State of Michigan, count one alleges that you did commit the offense of unlawful imprisonment regarding a Jennifer Larma. You understand the nature of that charge. I'm not asking you whether or not you did it.
Yes.
You understand what you're charged with.
Yes, Your Honor.
That's a felony punishable by up to 15 years incarceration, a $20,000 fine plus court cost. You understand that, sir?
Yes, Your Honor.
Count two is the offense of domestic violence or knowingly assaulting a pregnant individual, third or subsequent offense.
Did you say pregnant individual?
Said domestic violence and or knowingly assaulting a pregnant individual.
Your Honor, I have a clock here. I need to ask them to turn the volume up, please.
Hang on, sir.
Can you turn up the volume?
It's the third offense, domestic violence. Do you understand that, sir?
No, sir, Your Honor, because my ear and I didn't hear, and I wanted to clarify before I answer that. Did you say pregnant individual?
I listed the charge. I do not have knowledge that the individual is pregnant. I'm saying, let me redo that.
Thank you.
Domestic violence, third offense. Do you understand the charge, sir?
I didn't hear the things that you said before that, Your Honor, because my ear is plugged up and they just turned the volume up. So I didn't hear the full description, Your Honor. I apologize. I'm not trying to be difficult, Your Honor.
What didn't you hear the full of?
I thought you mentioned something in there, domestic assault of someone pregnant.
The full charge is domestic violence and or knowingly assaulting a pregnant individual. That's the full charge. So it could be domestic violence or it could be that you knowingly are assaulting somebody who is pregnant. It's a third offense. Understand the nature of that charge, sir. I'm not asking you whether or not you did it. I'm not asking anything along those lines. Do you understand what you were charged with?
No, I don't, Your Honor, because I'm not sure if you said.
All right, if you don't understand what you're charged with, we'll just do a formal reading. Here we go. You ready? I'll just go through all of the counts here because it's going to be this way. The complaints are alleges that on or about March 9th, 2026, at the location of 2717 Brooklyn Drive in Ypsilanti Township, Washtenaw County, State of Michigan, count one alleges the offense of unlawful imprisonment. that specifically is indicating that you did knowingly restrain. Why did they let him go? Call the jail, tell him, put him in his cell, get a tablet in front. He's going to be arraigned today. Court calls the case. Brianna Jardine.
Ron brought up hearing.
Brianna Jardine. Jardine.
Stay behind.
Oh,
Hi.
hi.
Hi. You going to get up and walk away too?
No.
Oh, okay. Go ahead. All right. Good.
Your Honor.
So we have Mr. Dovashevsky back. Mr. Dovashevsky, you got up and you walked away from me, but that's okay because I'm going to arraign you, sir, on this matter. And I'm going to indicate to you, we'll just start over and we'll get it done, that on the date of March 9th, 2026, at the location of 2717 Brooklyn Drive, Ypsilanti Township, Washtenaw County, State of Michigan. Count 1 alleges that you did commit the offense of unlawful imprisonment. It specifically states that you did knowingly restrain Jennifer Lerma by means of a weapon or dangerous instrument contrary to statute. That is a felony punishable by up to 15 years incarceration and a $20,000 fine plus court costs.
No, sit down.
Count 2 alleges the offense of domestic violence and or knowingly assaulting a pregnant individual, third or subsequent offense. That alleges that on that date and at that location that you did assault and or assault and batter Jennifer Lerma, an individual with whom the defendant has or had a dating relationship contrary to statute. That would normally be a 93-day misdemeanor. However, it is further alleged that you had previously been convicted of assault and or assault and battering of your spouse, the defendant's former
I do
spouse,
not
or an
consent to
individual
my
with whom you
images
had
or my
a
intellectual
dating
property being
relationship
transmitted
or an
over
individual
artificial
with whom
intelligence.
the defendant had a child in common or resident
I'm
or
sorry,
former
sir.
resident of your household, or knowingly assaulting a pregnant individual, and that you had done that on or about
He did say
February
pregnant.
25th, 2010 in Macomb County Circuit Court, and as a second domestic violence second offense, and on or about January 7th, 2025 in the 14B District Court. Therefore, upon conviction, you would receive enhanced sentencing. This is now a felony punishable by up to 5 years.
I don't understand what you're
a
saying.
$5,000
I don't
fine
understand
plus
what you're
cost.
saying.
Why don't you
I don't understand what you're saying.
If the assault
I don't
was committed
understand what you're
in
saying.
confinement, which it was
I don't
not,
understand
so
what.
I will not read that. Those are the charges against, 2 charges that are against you. I will indicate, since the defendant is not being cooperative, I fully appreciate that he does understand me, that the defendant is standing mute to these charges. I will ask the public defender to step in as his counsel, and I will enter a not guilty plea. Ms. Anderson.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson, within on behalf of Mr. Drobashewski. Your Honor, unfortunately, we were unable to meet this morning. The only information I have at this point is just contact information for him, and to advise the court that there's nothing else holding him in custody. We would ask for a reasonable bond pending the PCC date.
All right. Set a probable cause conference, I should say, in this matter for March 26, 2026, 9 a.m. As to the bond regarding the people.
Thank you, Your Honor. Gabrielle Ragland on behalf of the people. The people are requesting a high financial component in this case that is due to the serious nature of the allegations, and that there are significant lethality concerns regarding both regarding the victim, and we also have concerns about returning to court. We are requesting a bond in the amount of $500,000. We are also requesting no contact with the listed victim and a GPS tether with an exclusion zone of 2717.
Given the nature of the offenses as well as the defendant's conduct during arraignment, I will set the defendant's bond in an amount of a $500,000 cash or surety bond. I will order that if he posts that he would be placed on a GPS tether with the exclusion zone of the 2717 address. I would further indicate to this defendant that they are not to use or possess any alcohol, illegal drugs, including recreational marijuana. You're not to leave the state of Michigan without permission of the court. You are not to purchase, possess a firearm, ammunition, or other dangerous weapon. You are not to assault, terrorize, frighten, intimidate, stalk, or molest anyone. I will further indicate that you are to have no contact whatsoever with Jennifer Lerma, and what I mean by that, you can have contact with a civil standby. You're not to attempt to have any direct or indirect contact with that individual by or through in person or by or through others, through any electronic communication, including but not limited to phone, email, texting, internet, social media, or refer to those persons should you have access to the internet. You are not to refer to them online in any form whatsoever. You are also not to go to the stated address indicated of 2717 Brooklyn Drive, except with a civil standby, if that is your home address. You're not to violate any criminal law. You're to personally appear for all court proceedings and other places as directed by the court. I think I got everything. Thank you.
Thank you.
Okay, bye. Okay, bye. Yeah, that was a weird one. That was a weird one. I don't really have anything to say about that. Yeah, no, I agree with Judge Simpson. He completely understood what was going on. He was just being difficult on purpose. Trying to rage quit court in jail. You don't really have too many options of what you can and can't do. Yeah, somehow he got away with it for a second. Didn't work for too long. Let me grab these super chats real quick. Phil, thank you so much for your super chat. Sassy's late fee. Thank you, Phil, and welcome, Sassy Cheshire Cat. Never fear, trouble is here. Late fee. Good to see you, Cheshire. Good to see you. All right. Is it DeSanto next?
Thank you.
Ooh.
All right,
good
so
guess.
let's
Good
recall
guess.
the matters of the city of
Almost like I
Wyandotte
put this
versus
video
Christopher
together.
Gonzalez, 26282 and 161098.
Good afternoon, Your Honor. Excuse me. Good morning, Your Honor. Gilda Blair, on behalf of Christopher Gonzalez. Dr. Gonzalez, please state your name.
Christopher Gonzalez.
Thank you.
Okay, so counsel, before we proceed, is the fraudulent scheme one that your client's pleading to, or is it a dismissal? It's not quite clear on the sheet.
I'm sorry about that, Your Honor. It's the fraudulent scheme counts.
You have not missed Tope. You have not. That's I put that at the end on purpose. I've got the soft sit update and the Tope update towards the end of the video. So you have not missed her yet.
Be dismissed.
Okay, that's not very clear. Because it's underneath the drug paraphernalia, it looks as though it's part of.
Uncle Dan, thank you so much for the super chat. You're gonna cover any of the Afroman trials, sir? No, and I'll tell you exactly why. Because I live like 20 minutes from that courthouse, and there is one thing that I will absolutely not do is put myself in jeopardy of being held in contempt of court, and I am well within the jurisdiction of that courthouse. So no, absolutely not. I will not cover that trial, but a lot of other channels are doing it. So yeah. And I've been well aware of that case for, I don't know, when did it happen? 2-3 years ago? It was all over the local news. But yeah, no. I will not cover courthouses in my backyard for a very specific reason. They can find me very easily. Cheshire Cat, thank you so much. The solid black mixed Maine Coon kittens on Discord. Oh, cool. All right. Thank you, Cheshire. Thank you, Cheshire. All right. Yeah, right. No. I'm trying to avoid that. Absolutely trying to avoid that.
The plea to plead guilty on. So that's why I needed that clarification.
Yes, Your Honor. I understand that for the record, The plea is as follows. My client is going to plead guilty to driving while license suspended. That's B1. I'm pleading guilty to possession of drug paraphernalia. That's count A2. The other 3 counts are dismissed. There will be an additional count of civil infraction of no proof of insurance. You would be responsible for that additional civil infraction. That's what the record should reflect.
Do you also represent Mr. Campbell? Or is that?
Do I also represent Campbell?
Let me see here.
No, no, that's a co-defendant or the.
Yes. Oh, no, never mind. He was on earlier for a PSI. All right, sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
Your attorney worked on a very favorable deal for you, sir. As to the charge of driving while license suspended, how do you plead?
Guilty.
As to the charge of possession of drug paraphernalia, how do you plead?
Guilty.
As to the amended charge of no proof of insurance, how do you plead? Responsible or not responsible?
Responsible.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
I'm sorry, I didn't hear you.
Any immigration issues?
No.
Counsel, if you can please pardon your client.
Yes, I will. Mr. Gonzalez, you recall being in the city of Wyandotte on about the 4th of March of this year?
I do, yes.
And at the time you were operating a motor vehicle Saturn View, is that true?
Yes.
And you were pulled over by Wyandotte police officers and was determined that your driving privileges were suspended on that date and time. Is that correct?
Yes.
And during that interaction with that officer, the officer determined that in the vehicle there was a device identified as a crack pipe looks like it was in the driver's door. Do you admit that that was in your possession in that vehicle?
Yes.
You're satisfied with that?
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to count A2 of possession of drug paraphernalia and count B1 driving while license suspended, as well as the no proof of insurance. And counsel, are you asking for immediate sentencing, or are you wanting this court to conduct a pre-sentence interview?
My client would like to resolve sentencing immediately if that is possible.
All right, the court will do its best with the information that I have before me. Counsel, what do you want the court to know?
Mr. Gonzalez is he's a hardworking guy. He's been working the same job, works for Martin Tire. He's been doing that for at least 2 years. He has a child or children that he supports, pays child support. He would like me to point out to the court that he was arrested on the 4th on this matter. That's, I can't do math. Is that 12 days? How many days is that since then?
14.
For credit for those 14 days served, or would suggest to the court that may be sufficient punishment in this particular case. He has other matters he's going to be dealing with. He has a number of warrants, and so I don't think he's going to be released regardless of how the court treats that. Is there anything else you would like to say to the judge, Mr. Gonzalez?
No.
Okay, well, The court will note today is also the date scheduled for a jail review on the 1-6 matter. Mr. Gonzalez was actually scheduled for a jail review in this matter on May 7th, 2024, because on his probation violation from that matter, which was attempt possession controlled substance, multiple counts, this court ordered Mr. Gonzalez to 60 days jail, suspended. We set it for a jail review. The plaintiff failed to appear for that jail review. The reason we're doing the jail review now is because he was arrested.
I did like
On
15
this matter.
days
Excuse
towards
me,
that.
sir. Excuse me. Pause, please. Don't interrupt me. Is there a reason why you're leaning on the wall, sir?
No.
Sit up straight. You're in court. You're on the record. Sit up straight. And so this court will note that Mr. Gonzalez was also ordered to start random testing on that day as well. He did not contact probation to set up testing, did not test, did not show up for his jail review. He was to start paying $100 per month on April 19th of 24, did not make a payment, and he has as such been in warrant status since May 7th of 2024. Sir, what are you currently in custody on for the other warrants?
I'm not. I got picked up on the recent ones. That's what I'm here for.
What other warrants does he have, counsel?
You don't have that list, John.
Okay. Well, so Mr. Gonzalez, how long have you known Mr. Campbell?
A long time.
Sorry?
A long time.
A long time. Okay, so do you also know Miss Anderson, his girlfriend?
That's not his girlfriend. You're talking about Tracy Anderson and Keith Campbell. I have nothing to do with them people. I'm not related. You're confusing. I got arrested with Jeffrey Paul Campbell. Tracy Anderson is his uncle Keith's girlfriend, not his girlfriend.
You're correct. You're correct.
Okay.
I did get those two.
But what do I have to do with them people?
Excuse me. You're correct. I did get those two mixed up. I noticed that where you and Mr.
Judge DeSanto, that group of people has been haunting her court for the last, I don't know, month, 2 months. I covered Tracy Anderson's one of her jail arraignments, I don't know, a week and a half ago. This entire group. I understand why she got it confused, but I could tell his frustration. Like, I have nothing to do with them. Leave me out of it. This one gets better. Don't worry.
Jeffrey Campbell were arrested was right near the house of Mr. Keith Campbell and Miss Anderson at Emmons and Edcliffe Court. Again, stop interrupting me, sir. Stop interrupting me. That is why I got confused for a moment. The court will note that Mr. Gonzalez has many warrants. This one's from 10 years ago almost, an 18th district court failed to appear for arraignment regarding retail fraud. Also was on probation in the 23rd district court, failed to appear for probation violation, September of 2016. Then also have, again, back in Westland in the 18th district court, he failed to appear for a show cause on a plate violation. There's a warrant for that. And then in the 35th district court for a seatbelt violation, he failed to appear on or pay on. That's been warrant status since April of 19. Then we have 33rd district court, public order crime. He failed to appear for a show cause hearing on false information of a police officer. That date of that warrant was September of 2025, that we were able to get fraudulent schemes dismissed. So that was very good that your attorney was able to help you with that, sir. Then an invalid license also, you failed to.
Felix, I just found out that's a thing today. Never heard of that until today. So yeah, maybe it is contagious. I don't know.
To appear on for a show cause hearing. That warrant is also out of the 33rd District Court. And then you failed to appear for a show cause on a matter out of Flat Rock at the 33rd District Court. You were supposed to have been there February 5th, but you failed to appear on that one. So given all of your failures to appear and your failure to appear in this court on the 2016 case, where this court gave you an opportunity to not go to jail, sir, you did not.
All right. It is oppositional defiance disorder. Essentially, it's a disorder that, says that you have an attitude with everybody. I didn't. I'm not a medical professional. I don't want to comment on this too much, but yeah, if you have an attitude with everyone, you can be diagnosed with a disorder. Some people call that entitled, though. Just saying. I said I wasn't going to comment on it. This is why I don't do that.
Avail yourself of that opportunity. On the 161098, the court's going to order your client to serve the 60 days jail. You're to set up a payment plan on your balance, sir.
I cannot pay the money. Am I allowed to speak?
Not yet. By
Okay.
July 1st. You don't have to pay it in full. You have to set up a payment plan with
I
the court.
cannot pay the money. That's why I'm here. That's why all those old charges are still there. I do not have money to pay you guys. That's what all
Sir?
this is about. If I had to do the probation and just drug test and not pay the thousands of dollars that keep going up and up and up and up every time, I could do that. But this is about money. I do not have the money. I want to do the time and be done with this. I don't have anything to pay you. So then keep locking me up. Okay, then keep locking me up. I can't pay you.
Sir, this is not about money. It's not about money.
It's always about money every time.
Let me clarify, sir.
It's about money for me. I cannot pay. No fines, no cost, no court, nothing. I cannot pay you. If I could, I would have had this taken care of.
Excuse me, sir.
Yes.
The 60 days jail is because you did not do what you were ordered to do.
Okay, I'm responsible for that. I'm taking it. I did like 14, 15 days towards that the first time.
Sir?
Am I getting credit for that?
Sir? Let me ask this question. Do you work?
Yes,
you're not
for
in
2
custody,
years.
do
He
you
just
work?
told you that. I
I'm
work
sorry?
a mile from my house. He just told you. My lawyer just told you. I've been working for 2 years.
Okay, so then how do you not have any money to pay towards
I
fines
do
and
not
costs?
have the money. I do not have family. I do not have nobody. I have myself. I make barely enough money to pay for my one child and myself. I do not have the money, period. End of story. Or else I would have took care of this all these long 10, 12, 14 years ago. It's about money, probation. You got to pay for a vest. I do not have money. I want to do the time and be done with this. So I'm sorry. I don't have the money. Every time you say money, I'm going to say I don't have the money. This is what this is about.
Okay, this is not about money, sir.
Okay, so
This
if
is
I
about
show
you
up and
not-
don't pay, I'm going to go to jail, right?
Excuse me. This is about you not complying with the court orders of the court.
Then why
I've
are you
given
asking me about money?
I have given you an opportunity to not go to jail.
Okay.
Stop interrupting the court. I'm not telling you again. Stop interrupting the court. Our recorder can only record one person at a time. Stop interrupting. As relates to the 26.
Yeah, that wasn't me. That was something. I went back like 3 times to make sure that it was, a YouTube glitch and not a glitch on my end. So I think that was about it. I hope so. I don't know, but that little cutoff there, yeah, not my fault.
282 A and B matters. The court's going to order as to possession of drug paraphernalia. The court's going to order 45 days jail. Credit for 14 days. As his driving while license suspended, the court's going to order 45 days jail concurrent with count A. Credit for the 14 days, again concurrent with count A, and the court will waive the fines and costs in this matter. The other matter still is there. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
All right.
All right, he's got to finish his milk.
Okay.
Oh, it's
Okay.
probably warm now. No, don't drink that. You know what? You know he's in jail. That he probably needs to drink that. All right. Yeah, I don't know what to say about that. No idea what to say about that. So let's just keep going. That's the end of what I know.
So
Ooh, this is a pro se trial. Pro se traffic trial. This one's good. This one's good. We get a good not only is this pro se in a traffic trial, we get body cam, and we also have a nice Judge Tammy speech. Wait, we might not get body cam in this one. She had about 4 trials that had body cam. This might be the only one that didn't have it. But we got a good speech, which is why I put this in there.
Officer Cisneros, this is case 2025 TK 17305. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. So, Mr. Hudson, you're in the courtroom. You'll be able to ask any questions of Officer Cisneros when he testifies, and any other witness brought by the state. And you, if you wish to, you can bring evidence and testimony at the appropriate time. However, you do have a right to remain silent, and the state has the burden of proving the case against you beyond a reasonable doubt. You do not have to give any evidence or testimony if you intend to do so, but just please wait until the appropriate time till I've gone over your rights with you. Do you understand, sir?
Yes. Yes, Your Honor.
All right. So, Officer Cisneros, did I swear you in again?
Yes.
Okay. Mr. Brooks, your witness.
Yes, ma'am. Officer Cisneros, for the record of this case, please state your name.
Roberto Cisneros.
And are you employed with the Clayton County Police Department?
Yes.
Is it part of your responsibilities and duties to do traffic enforcement?
That's correct.
Would that include the area of Forest Parkway and Quick Trip Way?
That's correct.
What is that area, that streetway intersection, is that located here in Clayton County?
That's correct.
On August the 15th of 2025, approximately 2:08 in the afternoon, do you recall doing traffic enforcement within the school zone for a speed detection?
That's correct.
Now, in prior cases, I know you've recounted your training, but for this case, for the record of this case, recount for the court your training in speed detection.
So I am certified LiDAR and radar certified. LiDAR is the more accurate, where I specifically point to a vehicle. And on this particular day, I did point at a specific vehicle traveling on the school zone while the lights were activated.
Okay, and the way LiDAR works is, does it lock in on a specific vehicle once it's engaged?
That's correct.
Does it stay with that vehicle where the vehicle travels?
Yes. No, it doesn't state where the vehicle travels. However, it provides me with the speed.
Okay, and the way the lidar device that you were using on that date, had you tested for accuracy prior to your use before shift?
That's correct.
And to your knowledge, had it been calibrated within the year?
It's been calibrated within the year.
Now, on that date, did you record a speed or a vehicle traveling at a rate of speed 42 in a 25-mile-per-hour zone?
That's correct.
Did you initiate a traffic stop on that particular vehicle?
I did.
Was the driver an Adolphus Hudson?
Correct.
And when you initiated a traffic stop on Mr. Hudson, how did you identify him?
By his driver license.
The license, the picture that you saw on the license, was it similar or identical to the person that was seated before you?
That's correct.
Do you see that person present in the courtroom?
Yes. He has a white T-shirt underneath.
Okay. When you made contact with that driver, Mr. Hudson, did he make any statements to you about his speed?
Can I look at my citation?
If it will refresh your recollection, I encourage you to.
I don't recall what he said, but I put there's a drop menu where he's complaining about his citation.
Okay. Ultimately, were you successful in issuing the citation?
Yes.
And to be clear, that school zone area, do you recall what school is within that school zone area?
I don't recall the name, but I know there's a Quick Trip in that vicinity.
Okay. And we're talking about Forest Parkway and Quick Trip Way.
That's correct.
Do you remember the grade level? Is it elementary, middle, or high?
It's elementary school.
Okay. No additional questions at this time, yeah.
All right. Mr. Hudson, did you have any questions for Officer Cisneros?
Yes, I do, Your Honor.
Okay, go ahead, sir.
One question I have is, where were you sitting in the Quick Trip parking lot when I pulled up to the light?
I'll have to look at the camera. I'm positioned on Quick Trip parking lot, or I'll be positioned right in front of the McDonald's, or I'm sorry, IHOP.
Okay. Do you remember me stopping at a light?
I would not pull you over if you stopped at a light.
Okay.
Unless you were already coming, I already clocked you going over the speed limit, then I will pull you over after the stoplight.
Are you familiar with that? There being school zone differences on both sides of the street. So I'm familiar with that school. The school is called Utopia. Previously, we've had contracts on that school. And I previously worked in the Atlanta public school system, so I know this area. Are you familiar with that particular area? There's on one side of the street, you got school zone all the way down the street. On the other side, the direction that I came, which I'll mention and I'll allude to that in my testimony. But do you remember the conversation you and I had? And one of the reasons why I'm here, I asked you, I said, well,
Mr. Hudson, you're testifying, sir, and it's not time for that.
Okay,
and
I'm sorry.
Number one, and number two, you got to ask short questions that are answerable, because you keep asking a question and then you go on to another thing. Okay, so ask him a question, let him answer it, and then go on to your next question.
Okay. After looking at my driver's license, what did you see on my license?
I don't recall, sir.
Do you remember me mentioning that I was a disabled vet?
I'm a veteran myself, sir. But to answer your question about the street, the lights activated, if you're coming eastbound, it is located it's after Highway 42 and Forest Parkway, and the other street light indicating the 24 miles per school zone is located on the westbound on Forest Parkway and 675 South.
Yes, sir. Your Honor, that's the end of the questions I have for him. I'd like to address what my testimony is.
Okay, Mr. Brooks, did you have any follow-up for Officer Cisneros?
I do not, Your Honor.
Okay. All right. Did the state have any additional witnesses to present?
One moment, Your Honor.
And we got dead air. Yay, dead air.
Not at this time, Your Honor.
Thank you. Thank you for saving me,
All right.
prosecutor.
The state rest? Mr. Brooks?
The state does, Richard.
All right. So, Mr. Hudson, you have indicated that you wish to testify. You understand that there's no one can make you testify or give up your right to remain silent. Do you understand that?
Yes, Your Honor.
All right. Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right. You can put your hand out. So you, is it true that you intend to waive your right to remain silent to offer testimony in this case?
Yes.
All right. Nobody's forced you in any way to get you to do that or promised you anything to make you do it?
No.
Okay. Go ahead and tell me what happened, sir.
Yeah. On this particular day, I was pulling out of we have a contract on the BP station there on 42 in Forest Park. And when there's a light, and I have a picture of that light. And that light says they follow the speed zone when light flashing.
Okay, what were you saying, sir?
On that particular, coming from that direction from 42 in Forest Park, there's a light.
Okay.
And it says school zone.
All right, hold on, Mr. All right, okay. I can't hear you and see you at the same time because the microphone is back on the other place, but I can see. But sir, I'm going to tell you, this doesn't give me a whole lot of context because all you're showing me is the light. Do you have anything that shows me the light in context with the street or any buildings? Okay, I can't hear you at the same time. So unfortunately, we got some limitations on the audio in the courtroom, okay?
I thought that I was going to have a chance to show this information to the solicitor prior to.
Well, you would have if you had chosen conference.
But I thought about conference, but that's okay. You know, the only reason that I decided not to go forward just paying whatever the ticket was, but for this officer insulted me. And by him telling me that don't give him that manure in terms of me being a disabled vet. And that was an insult. It was insulting to me. But the Utopia School, which I'm very familiar with, because I know the people that's administrators of that school. So that's the school he didn't know about, that he works that area. But coming out of 42 in Forest Park, there's a light that says 25 in the school zone when the light's flashing. That light does not come on, and I did the research. On that side, that light comes on at 2:30. He gave me a ticket at 2:08. Now on the other side, because I drove the other side, there's signs that says school zone, school zone. On that side, when people are coming, they're going, or even if me driving that fast, and I've never had a speeding ticket in 53 years, that's upsetting. I get people blowing the horn at me because my tag says handicap, so speed up, not the speed. You know, and I have a problem with that, a serious problem. And the reason why this officer pulled me over, I told him too. I said, my spirit told me he pulled me over because I opened the container. I had a 7-Up bottle and I opened it up. That's when the lights came on.
Mr. Hudson, so yes. I'm a mama in elementary school. So my son is 2 years out of elementary school. Elementary school, we always had to be there in the 2 o'clock hour. So when you say the light doesn't come on until 2:30, that hasn't been my experience because usually the light is on because they get out around 2:30.
That particular school, you know, it's not only it's a middle school. They go up all the way up to middle school. And like I've said, I've previously stated, I've had the contract on that school. I know when they're out because that's when we service the buildings. So on that particular location, that light, whether it was working or not, that light, I'm taking a picture, that light comes on at 2:45. All right.
You just said it comes on at 2:30.
I don't know, 2:30 to 2:45. They don't get out of school till 3:45. The light comes on an hour before and an hour after.
Okay. Mr. Brooks, did you have any questions for Mr. Hudson?
I do. Mr. Hudson, you just testified that you hadn't received a citation in the last 53 years. Is that correct?
It's not speeding. I've had
Oh,
a citation, not
oh,
speeding.
you haven't received a speeding citation in the last.
Yes, sir.
But
Not
you
a
have
speed.
received citations for other things, correct?
I've had another ticket, but I have not had a speeding. We're dealing with speeding right now. I have not had a speeding ticket in 53 years.
Okay, that wasn't my question. I said, but you have received other citations for other traffic infractions, correct?
I didn't say I was an impeccable paragon. I stated that I never received a speeding ticket.
Okay, did you hear my question?
Yes, and I'm telling you, I'm
Oh, that's a
answering.
yes or no?
No, no. Yes, I received a speeding ticket. A ticket.
Okay, all right. Now you're aware that Utopian Academy is both an elementary and middle school, correct?
Yes, sir. Now, I understand they got a high school around the corner, not too far from them.
That's correct. And you know elementary school students get out before middle school students. You're aware of that?
Yes. I'm only going by what that light said. The light says that I have to drive the speed limit when the light is blinking. And if the light's not blinking, what else am I to go by? There's no other signs on that side of the street.
Okay, so your
Now,
testimony.
if I'd have been on the other side of the street, I would have made sure that I adhered to what the signs were. But on that side, it says the blinker, the speed limit is when the light's blinking. And if the light's not blinking, what am I to do?
Now, Mr. Hudson, you've also very adamantly testified that you're very familiar with that area, correct?
Yes, I am.
Not only are you familiar with that area, you're familiar with that school, correct?
Yes, sir.
And so you know when the school is in and out of session, correct?
Yes, sir.
And so
this particular day, sir, I was focusing.
Let me finish my question, Mr. Hudson. Let me finish my question. Whether the light is flashing or not, you know when the students are actively in and out of the building, correct? That would be common to a person who's familiar with the school, correct? That's a yes or a no, sir?
It's going to be a yes. I know when they're out. But the point I'm making with you right now is that I was not speeding. And if he's got me on a radar, show it. And not only was he to show it, I don't speed. And that's the point. Now, I got to bring 5, 10 people in here to tell you this man never speeds. Now, I've got a ticket, okay, for a car that something else that was done, but that was a NOLO plea. But the point is, I don't speed, you know. And I explained that to the officer. He gave me he gave me a warning for taking my seatbelt off after he came back to the car with the ticket. He said, "You took your seatbelt off." I didn't know you're supposed to keep your seatbelt on once you pull over.
Okay.
But who broke the plunger? Come on.
Anything else, Mr. Brooks?
One moment here.
Your Honor, can I add something?
Hold on, Mr. Cesaros. You're not my witness. That's up to Mr. Brooks.
No additional questions, Sharon.
All right. Mr. Hudson, did you have anything else at this time, sir?
No, Your Honor. But as I've stated previously, when I opened that container, that's when that light came on. That's when he got behind me. And I told him, he can probably attest to what I said. I said, you pulled me over because you thought I had an open container. And I'll take that to the grave.
Okay. Mr. Brooks, did you have any argument at this time?
State of reserve, Your Honor.
All right. So, Mr. Hudson, did you have anything else you need the court to know?
That's it, Your Honor.
All right. So here's the thing. So, Mr. Hudson, you stated several times that you're familiar with the area. You have a contract with that school. But the court is really familiar with elementary schools, and I happen to know that they get out in the 2 o'clock hour because what they do is they graduate the times that kids get out. And so my son is in middle school now. His school gets out at 3:15. When he was in elementary school, I had to be there by 2:15. So I know that once that light starts coming on in like right at 2 o'clock in any school zone. Now this light may have been malfunctioning, but it's still a school zone. And so you understand that as long as school is in session, you have to slow. And I get that you're looking for the light to indicate it, but it wasn't a holiday time. It wasn't summertime. School is in session. And so when school is in session, you have a responsibility to drive the speed limit that is indicated when school is in session, sir. Couple of things I want to address. So I have all the respect in the world for veterans because my mom is one, my aunt is one, uncles, my dad. And so, but what happens when somebody gets pulled over and the first thing they say is, I'm a disabled veteran, they're virtue signaling, which means they're trying to get the officer to give them more credit for whatever they are about to say next because they're a veteran. Officer Cisneros or any other officer can still appreciate your service to this country without giving you the benefit of the doubt because you're a veteran. Veterans have broken the law, veterans have speeded, veterans have gotten traffic offenses. So that's why you getting upset about him not getting all excited because you were a disabled veteran. Well, he's a veteran too. And so officers hear all the time. Like I had a lady in court the other day and she kept trying to tell me, well, I work for 911, not in this county or not in that county, but I work for 911. Well, what does that tell me? You want me to find in your favor because you are associated with law enforcement. Well, let me just say that if the person is doing their job the right way, that makes not one whit of difference. So to tell somebody I'm a disabled veteran and then get mad because they don't fall all over themselves because of it, sir, you're being stopped for speeding, not for anything that has to do with your service to this country. And while I say I appreciate it, and I'm sure many, many other people appreciate your service, it has nothing to do with whether you went through that light. So your testimony was contradictory in several ways because first you knew everything about this intersection because you have a contract there, but then you're telling me that the light doesn't come on until 2:30, then it doesn't come on until 2:45, then the kids don't get out until 3:45, and sir, those things just aren't true. And so what I'm saying is I'm going to find you guilty of the offense as charged. Guilty of speeding in a school zone, 16 to 20 miles per hour over the limit. Mr. Brooks, did you have a recommendation for the sentence in this case?
What's up? $100 fine.
All right, so the fine will be $100. It'll be $153 with the surcharges. Did you wish to pay that today, Mr. Hudson, or did you wish to have additional time?
It is 60 days.
All right, so I'll give you 60 days. So the last I'm going to ask you to do is go down to the second floor. When you come back through the double doors, you're going to go to your left to the traffic court window. You're going to pick up your paperwork. You can also make your payments there at that window, or you can ask them about how to pay online or by phone, okay?
All right, thank you.
All right, be safe, sir.
All right. All right. I just wanted to work up your appetite for the Tope case. That's next. We are jumping to Judge Simpson's courtroom. Yep, Miss Tope showed up. She showed up. And I'm going to say about 90% of it is exactly how you expected it to turn out. That's what I'm going to say. Let's go. Judge Simpson, Miss Tope.
Call the case of Fixing Housing 401k versus Erica and Aaron Ward in regards to the bench warrant issue. This is a matter involving Donna Tope. Ms. Tope.
Yes.
Good.
I think she could hear fine. She just wanted that close interaction with Mr. Allen. Understandable. I would too.
State your name.
Donna Tope, I'm hearing on behalf of myself.
Ms. Tope, I had issued a bench warrant for your arrest for failure you to appear at a show cause hearing, which I know that you had notice of. You filed a motion in this case to remove and expunge the court's order for contempt and the warrant for your arrest. That is your motion before the court today.
Yes.
Go ahead.
So I would like to put this on the record for my own purposes and also for YouTube. The YouTube that was recorded when you issued this bench warrant has been used against me in my professional capacity and for other cases. And therefore, I would like to have this on the record.
Have what on the record?
What I'm going to tell you now in my defense.
Go ahead.
Okay. It's my motion. The following enumerated facts support my motion to remove and expunge from every record, including the YouTube video: A, your order for contempt, your warrant issued for my arrest, and your order to hold me under arrest on $10,000 cash bail. I received the judge's final docket for hearings set for Tuesday, February 3rd, 2026 at my email address on Monday, February 2nd from Ms. Weedling. I opened the email the morning of Tuesday.
Oh, that wasn't me. Sly did. Sly called him. Yeah. It was our first trip there. Sly said it to him. He's like, "Yeah, we have a nickname for Mr. Allen. It's the Buff Lift." Yeah, and he laughed. He laughed and he blushed, but he was cool with it. So yeah, he's forever known as the Buff Lift.
February 3rd, because I am a party in a completely different case before this court, and I looked for something on that case on the docket. To my surprise, the docket for 2 p.m. that very afternoon had me listed for a show cause hearing on a case for which I am neither a party nor an attorney. Not having had any notice of appearance for this hearing, I was not able to get to the court in time, so I sent Ms. Weedling the email, which I attached on my motion as Exhibit A, explaining that to the court. I receive all of my business mail at Post Office Box 1283 in Ann Arbor, Michigan 48106. I check my mailbox weekdays after 5 p.m. On Thursday, February 5th, 2 days after the unnoticed show cause hearing on the court's February 3rd docket, I sent Ms. Weedling the email and photos provided at Exhibit B. The email describes what I received that morning, Thursday, February 5th, 2026, in my post office box, 2 days after the hearing was held. The photos included with my email to the court are of a motion, affidavit, and order to show cause signed by Judge Simpson, along with the postmarked envelope they were mailed in. Exhibit C is hard copies of those legal papers and the envelope. The motion at number 2, page 1, states, I am being held by the judge in contempt for filing a pleading without my client's knowledge, nor being the attorney of record. At number 3 on page 1, Judge Simpson requests an order to show cause why I should not be found in civil contempt of court. Can you attach it for me? Thank you.
Like I said, yeah, no, I get it. I get it, Miss Tope. one of the only things I'll agree with you. Yeah, you want Mr. Allen to stay next to you. I get it.
At item 5, page 2, I am ordered to appear before the court on February 3rd at 2 p.m. At 7 on page 2 of the order to show cause, it states that a copy of this order must be served by mail on the person ordered to appear, which is me, at least 14 days before the hearing, which had been set for a hearing on the docket for February 3rd at 2 p.m. The judge's signature is dated January 20th. The envelope is postmarked January 28th. The date the post office mailed it, which is only 6 days before the hearing date of February 3rd, which is not the quote, service by mail within 14 days required by the judge's signed order. I received the order at my address on February 5th, 2 days after the hearing was held, and only 8 days after it was mailed, which is 6 days shy of the required 14-day notice by mail. The facts are that I was not properly served nor properly noticed of the hearing at which Judge Simpson found me in contempt for not appearing. The further facts are that in finding me in contempt for not appearing, Judge Simpson issued a warrant for my arrest and demanded an excessively punitive cash bail of $10,000, or so I was told by a person who was in the courtroom when Judge Simpson put his order for my arrest on the record. Based on what I have provided, the judge's motion and order, and the mailing envelope, I am asking for the following relief from Judge Simpson. Please retract, remove, and/or expunge all records of the order for contempt, the bench warrant, and cash bail issued by the judge, so that there is no evidence out on the web that the judge issued the order, the warrant, and the excessively punitive bail. I include court records, transcript records, and the YouTube video of the judge's orders that another attorney alerted me to in cases that I am appearing in 3 other circuit courts, and reissue with proper notice to me the show cause hearing the judge wishes to impose upon me. I am perfectly happy and willing to appear at a show cause hearing if I have proper notice. I did not.
This is your proper notice. You had notice. I will stand on the record that I made that day that you had notice of that hearing and that you failed to appear. And my staff indicated that. You can argue with me all you want, Ms. Tope. What I will do, though, because you have part of the reason that the bond is set in the amount that it was, is because you had basically been removed from the case, this case. You had filed a pleading, you signed it. Your former client had no knowledge of it.
That is not,
was delayed.
Not correct.
You want to know what? Do not interrupt me, because then there's going to be a whole other problem. Your client stated on the record they did not have no knowledge of it. Defense counsel or plaintiff's counsel had to respond. The amount of the bond is the amount of billings that the plaintiff had incurred based upon you filing pleadings when you weren't supposed to and the delay that you caused. It was set in that amount. What I will do is I will cancel the bench warrant. I will reset your show cause hearing. So here's your notice for April 14, 2026, 9 a.m. Thank you.
Best thing Tope did was not say a word and just walked away right there.
Have all your witnesses, and if you wish to be represented by counsel, you need to have counsel present at that proceeding.
Thank you.
Are you understood? Am I understood?
Clearly.
Thank you.
Who wants to go next? I said this from day one. It is very, very unlikely for an attorney to go to jail for something like this. Yeah. As long as she showed up and made an appearance, yeah, she's gonna get slapped with a pretty hefty fine. April 14th though. April 14th. We'll see. We'll see what happens. She's gonna get. I cannot wait for April 14th. That's gonna be my favorite day in April. No, that's not true because Heather's gonna be here the first couple days of April. It's gonna be my second favorite day in April after she leaves. Okay, you know what? I'm just gonna stop talking. I don't think Heather's listening, so I'm just gonna stop talking. All right, gonna move on to the last game. And there is an absolute reason why I hid that Tope video at the end of this. Yeah, no, I don't want her finding this video and be like, take this down. Yeah, I hit it at the end. Didn't play at the beginning. Hopefully, she gets bored by all my commentary and court cases before she gets to that one. If she watches this video, anyways, let's move on. We have the cake pan sob sit herself. She had an appearance yesterday. I think it was yesterday. I don't even remember. But Cake Pan Sob Sit has lawyered up. So it's not that exciting, but it's a follow-up, and I wanted to play it, so we're going to play it. And this is how we're going to finish the video tonight. And I'm just going to let it play out because it's only about 2 or 3 minutes long, so I'm just going to play the rest of the video out, and I'm going to peace out. It is Wednesday night. I will go look for someone to raid, and right at the end, I'll pause it to let you know who we're raiding. But thank you guys for the super chats, gifted memberships, membership milestones. You guys are awesome. Mods, as always, thank you so much for your hard work. You guys are awesome. I'll see you tomorrow night at 7, not 8. It is yoga night, so it will be at 7. But I'll see you guys tomorrow night. And like I said, I'll one last pause right before the end to let you know who we're rating. Okay, bye.
And how about Attorney Peterson? Do we have Attorney Peterson on Sydney Taylor Leslie? We have Sydney Taylor Leslie or her attorney. There's
Yes, we're here, Your Honor.
Is she with you, Mr. Peterson?
No, she is separate.
All right.
Sorry,
I see her next to you on my screen, so that's convenient. We are on the record in BU 2025 CR 250, State of Kansas versus Sydney Taylor Leslie. Please announce appearances.
Jared McGear on behalf of the state.
Sydney Leslie appears on Zoom with counsel William Peterson, also by Zoom.
How does she wish to proceed today, Mr. Peterson?
Your Honor, Ms. Leslie and I are here because we put this back on the control docket, trying to work things out. Since I took over the case, we've been unable to do that. So we're requesting this be put back on for a jury trial setting.
Jury trial setting, when's our next one? Is that in June also, Jim?
Yes, Your Honor. Pre-trial is going to be June 22nd with jury beginning June 24th.
Now, Counselor, I would be happy to put you and the prosecutor in a breakout room and try to get you to work this out today if you think that's at all possible.
I don't know if it's at all not possible, but I don't think a breakout room today is going to work for us. So,
well, this will be continued then at the defendant's request for pre-trial June 9th, 9 a.m. You must be back here, Miss Leslie, at that time with your counsel by Zoom for pre-trial ready to proceed. But you must also be back here live in person June 24th and 25th for jury trial in person at the courthouse. And I will continue your bond, the $3,000, looks like cash bond, maybe that you posted May 21st to 25. Anything else, Mr. Regier, for the state?
Forgive me, Your Honor. I might have been experiencing temporary technical difficulties. What is the setting for the jury trial?
I'm told the jury trial itself is June 24th, and I always give them 2 days in case it carries over. And then pre-trial June 22nd.
Very good, Your Honor.
I think I said that right, didn't I, Jen?
Yes, Your Honor, you are correct.
All right, thank you. All right, anything further, Mr. Peterson, on this matter?
No, no, thank you.
You're welcome. And Miss Leslie is excused. And do you have any other clients on this?
All right. Yep. Just a quick update with the cake pan subset. She lawyered up. That entire group lawyered up. Quentin lawyered up. I don't remember what her boyfriend's name was. He lawyered up. Like all three of them. That was that was a really big group that we were following for a little bit, and they all left the soft sit group and hired the same attorney. So I mean, good for them. That's smart, getting an attorney. I wish we could see the jury trials. We're not going to be able to though, unfortunately. I've never seen a trial that I've never seen a bench. No, I haven't seen a jury trial with Judge Webster. Generally, we just get the traffic trials every once in a while, but that's about it. So unfortunately, we won't get to see it. But I wanted to give you the quick update. Hopefully, you enjoyed it. Anyways, we're gonna head over to Lone Wolf, and that's it. I've already thanked everybody, so I'm just gonna peace out. Go tell Lone Wolf I said hi. Okay, bye.
Docket, Mr. Peterson?
I do not.